All rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. Good morning. Those who are comfortable doing so, you should feel free to remove your masks. We are here for oral argument this morning in CV20-03660, Neary versus the Arizona Board of Regents et al. As I presume you know, we record and live stream these proceedings, so you are encouraged to give your name and the name of your client when you begin speaking. And as you can see, under our current protocol, you will be arguing from council table. I actually don't know if they've fixed if you can see the timer from where you're at. But if you can't, you should feel free to move about as needed to check your time. Because we do require you to keep track of your own time. Each side does have 20 minutes. You're not required to use all that time, but you are welcome to do so. Will the attorneys over here be splitting time, or is somebody taking points?
I'll take the lead, but I'll reserve some time for co-counsel.
Okay, well, that will be up to you to
Yes.
do, and we'll encourage you to handle that how you'd like. Please do keep in mind, as I'm sure you know, we have conferenced the case this morning. We've reviewed the briefs. We've reviewed the record in the case. We've discussed the case. And with that, please proceed.
Thank you. May it please the court. Good morning. My name is Veronica Manolio, and I represent plaintiff, who is now appellant, Douglas Neary. I know the court has read everything, so I won't bore you with the facts. We're here for two limited and pointed issues. The first being that the trial court in this case misapplied a legal duty that was owed by the defendant ABOR, or the Arizona Board of Regents. The second issue is that of legal or proximate causation as to the injuries that were sustained by my client, Mr. Neary.
Counsel,
Absolutely.
just to clarify,
Sure.
on that second issue, taking for the moment that the assumption that we agree with the trial court on legal or proximate cause, do we need to get to the duty issue with regard to ABOR?
If you agree that there is no causation, then the duty becomes irrelevant. I agree,
Okay.
and I think the court even said in his minute entry it's a moot point.
Right.
But because, I apologize.
Well, so I was going to encourage you maybe start with point 2.
No
for us.
problem. That I can do. And I think that's the more important issue, because here's where we are. This is a case where the judge made an evaluative judgment on causation. There is such an intermingling in the courts, and let me be very clear, I respect this trial court very much, and I understand the analysis that was done. This is one of those cases that has a good analysis, meaning the judge clearly put time and energy into the analysis on causation. But at the end of the day, the judge substituted his own evaluative analysis as to what a reasonable juror could do. And reasonable jurors don't have the kind of experience that Judge Brodman, quite frankly, footnoted and said he has, having watched thousands of games and participated in sports for years. The issue of causation should have been evaluated by a trier of fact because there's evidence in the record of an increased risk of harm and foreseeability. And there is no pronouncement by the trial court that there was a lack of evidence. The judge clearly said, I don't find these factors that you claim are evidence to be relevant. But that's an evaluation that was within the province of the jury.
Are you saying that because of the nature of the element of causation, summary judgment is never appropriate on that ground?
Absolutely not. I'm not saying it's never appropriate on that ground. I'm saying in this case it's not appropriate because the level of evidence that existed was sufficient to reach a jury's evaluation.
And what are those facts at issue?
Those facts at issue include the fact that this player was a varsity player, and I apologize having a contact issue. This player was a varsity player that ASU specifically moved down to a JV match. In his words, pumped him up, knew he was a leader, and would do whatever it took, while knowing he was ineligible, and not just ineligible by a mistake, ineligible by not having been an ASU student for 3 years. He was not registered. and he was not allowed to be on the field, period. You couple that with the fact that he flagrantly said within hours of doing this incident, ASU has no jurisdiction over me. There are facts that a jury should evaluate to say those all show an increased risk of harm.
So a jury reasonably could have found that ASU should have anticipated that the person would commit a crime.
ASU should have anticipated that players on a rugby field would commit a crime, and here's why. Again, because you asked earlier, is summary judgment never appropriate? In the other cases that were cited by the defense and cases that are distinguishable, I agree that could be different, but in this case, it's rugby specific. And the reason I say that is rugby is a sport that is designed by nature to include multiple assaultive acts. If you look at the regulations and the penalties for rugby, it includes a long list of things that are considered criminal assault. I don't know of another sport, and I don't think the court would think of another sport where testicle torsion is one of the regulations. You can't kick an opponent in the face. You can't drop someone on their head. You can't pick them up and not drop them on their head. You can't unreasonably kick. All of those acts are anticipated within the sport of rugby.
But don't we get to a point where the act is so egregious that it's just outside of what's expected?
Could be, and I agree. Let me rephrase that. I agree with you. That is, but the point is when it's off the field. And that's what the cases cited by the defense actually aimed at. Each of those were acts that occurred after the stoppage of play and off of the field. The defense has done a really good job in this case of saying because this event happened during a stop and play, it wasn't in the play of rugby. Well, a stop and play is as easy as a whistle blows and the team relines up for another play. This is not during halftime. This isn't during a break. These aren't people who are out in the parking lot or at a bar partying afterward. This is in the heat of competition in the middle of a game with a heated rivalry between two schools that are known to be each other's biggest rivals. So it is within the course of play, and that's what makes it a contemplated risk in this case. I'm not asking.
But aren't there assaults even within the course of play that could be so outside of the norm that would not be foreseeable?
Theoretically, I mean, if it's within the course of play and someone pulls out a gun, that's an assault that wouldn't be foreseeable. If it's within the course of play and someone kicks another person because they're angry, that's foreseeable. But that question of whether or not it was foreseeable and whether or not there was an increased risk in this case should have been reserved for the jury. And what I believe the court did was substituted his judgment of, I think this was outside of the norm, for what a jury could have considered. And the reason I say that's a foreseeability question for the jury is because there's sufficient facts surrounding it, including the fact that, the play had just stopped. This player says something happened that no one else saw. This player says he was hit first. No one else saw it. Those are things that will help a jury decide, was this foreseeable or not foreseeable?
So we've seen in these and other sports, there's shoving that happens sometimes and the litany of assaultive acts that you mentioned earlier. But how often do we see aggression to the degree that we saw inflicted on Mr. Neary?
Well, I don't know that I can give you a measure of how often we see aggression.
Have we ever seen that type of assault before?
When you say we, you mean is there a case in Arizona that I could find to point to? The answer is no. And when you say, have we ever seen...
Or even for ABOR, for ASU or U of A?
Well, there's a fact dispute on that. And again, I've raised the fact dispute because while the coaches said, I've never seen anything raised to this level of aggression, they clearly, and coaches from ASU, Lane and Lopez in particular, have had other instances where there have been such egregious acts that there were disciplinary measures. But I appreciate where you're going, and I completely understand what you're saying. If this was so out of the norm, but it's not so out of the norm that it's not contemplated. And that's the distinction, in my opinion, with rugby, and that's the distinction with why this case is one that should be evaluated by reasonable people.
You're suggesting that this is contemplated in rugby because of those specific regulations that you pointed to, right?
Correct.
But don't those regulations go to the type of conduct that can or cannot occur during active play?
It never says during active play, and to be very clear, the USA rugby rules say on the face that it's on the rugby field and off. The rules say these are intended to prevent safety, to promote safety and prevent issues. But they also talk about
Well,
the
if
conduct.
you're saying that that then sort of extends this potential liability to all conduct falling within these regulations off the field, then it seems like you're suggesting that the liability for ABOR, for these coaches, would attach if one player drops another player on their head at the party down the street after the game is over. Is that what you're saying?
That's not what I'm saying. I think
Okay.
that's what the regulations
How-
read. The regulations say that it's a course of conduct on and off the field. But I believe that the regulations should be registered for rugby players during the course of play. My position is the course of play includes being on the field, but during a stoppage. You're on basically a timeout. It's just a realignment. What happened here was a whistle blew and there's a realignment to start the next play. It's not a
So
stoppage.
what is in the record in terms, you suggested that the coaches have seen and disciplined for egregious conduct in the past. Can you give us an example of something in the record that these coaches were aware of that occurred during a timeout, egregious assaultive behavior that occurred during a timeout and resulted in discipline? Is there something in the record that gives us that frame of comparison?
There's not a specific instance, and I will be clear with you. The only instance I clearly remember from the record is the deposition testimony of Gary Lane, where my then partner Merrick Firestone asked him, "Haven't you seen other issues or had similar issues in the past?" And that was the only thing in the record, but they didn't get into details, excuse me. So I can't tell you, and I'm not going to try to represent what happened because I don't know the facts. But I think again, that takes away the focus of what is this case bringing to the table? This case in particular, because I'm not asking the court to announce a bright line rule that says every time you have safety rules, a player has to follow those safety rules on the field, off the field, during play, out of play. The issue here is if it happens on the field during the course of a game, that's considered the play of rugby. And that's sufficient to have let a jury decide it. I agree with the defendants that, oh, I'm sorry.
So it is foreseeable in your view, anytime there is a combative or close contact sport, that criminal activity is foreseeable.
I wouldn't say every time. A close combat sport, yes, there's going to be assault, not criminal acts, because the distinction, as you said, are criminal acts foreseeable. The criminal act of assault is foreseeable in a contact sport because it's bound to happen. But in particular, when you say criminal acts, I don't want to...
But if you look at rugby, if you look at football, even if you look at basketball, there's activity that I think is sanctioned within the bounds of play that in the outside world would be assaultive criminal activity. So I don't see, I'm having trouble with the rule that you would have us adopt.
Okay, and here's where the line is. In the outside world, you're right. Kicking an opponent unfairly or kicking an opponent in the head doesn't seem reasonable. In rugby, not only is it anticipated, it's articulated as, hey, this is a violation. Don't kick someone in the head. Don't kick someone more than what you need to do. It's basically what the rule is. So we can't say...
But if the rule prevents the conduct, then why is it foreseeable that... So we're saying that it's foreseeable that individuals break the rules and as a result their coaches should be held financially liable?
It's going to happen, is what I'm saying. It's foreseeable that it's going to happen. The rule is there to prevent it, but the way to prevent it is to be able to implement a foul, a penalty. Oops, I apologize. Some sort of a play, or excuse me, a flag on the play. Let's take your football example. If you're playing football and you do something that's outside of the bounds of play, you're going to get a flag on the play. But what you're saying is if it's so egregious and a player gets ejected, isn't that unforeseeable? Perhaps in football it is. In this sport, it's anticipated that's going to happen. It's anticipated that these assaultive acts are going to happen on the field. And because they are anticipated, they are foreseeable. Whether or not it's so egregious or it's outside the bounds of all decent contact or conduct on the field is a question of evaluation. A reasonable juror may say, I don't think that was so far afield that they shouldn't have anticipated, given the fact that they had all these other factors of knowledge. Meaning, you know this guy is not eligible. You know this guy hasn't been a student or played for 3 years. You know this guy wasn't registered, and he's been playing varsity level games that are subject to AAA regulations for 7 games at least.
Which of the things that we know about this guy suggests this level of criminal assaultive conduct?
None. And that's my point. The rule is not that someone has to have a propensity towards criminal violence. What we do know about him is that he has a flagrant disregard for rules. And in this case, under these facts, that's sufficient to say what he did.
Don't we need something tied to the rules that you are most concerned about? For example, if he had been previously ejected, or red card, yellow card, something like that to tie his disregard for the rules to the rules that are at issue, which is the rules of physical contact and conduct.
Those would have been indicative, but they're not dispositive. There should not be a requirement that you have to have knowledge of a propensity towards violence, or you have to have knowledge of prior criminal conduct in order to have foreseeability. A reasonable juror may say, there were many signs they should have recognized that this guy had more of a propensity, or that he created an unreasonable risk of harm. I think I've answered all the questions that have been posed just yet. If there are other questions, I'm happy to take them, but I do want to reserve at least a few minutes for rebuttal, if that's okay with the court. Are there any other questions before? Thank you.
Good morning. May it please the court, my name is Brian Bergen with the firm of Bergen, Frake, Smalley & Oberholzer. I'm counsel for one group of the appellees, the defendants, the student defendants. The Superior Court correctly dismissed the appellees, all of us, as defendants of this action and properly assigned liability where it belonged, with Jordan Crawford, as a result of his criminal assault on the appellant. In so doing, Judge Brogman correctly ruled that Jordan Crawford's criminal act was an intervening and superseding act, breaking any causative chain that may have existed between any breach of duty owed to the plaintiff by any of the defendants. As our brief reflects, we submit that the result was correct and that the Superior Court's analysis and ruling on the superseding act was correct. The grant of summary judgment in favor of these defendants should be affirmed.
Counsel, I take the other side's argument on rugby is by definition so violent, and apparently the players don't abide by the, it's foreseeable that the players will violent and not abide by the rules of rugby. Do you have a view on that?
I do, and thank you for the question, Your Honor. The assertion and the statement, undisputed as it may be, that rugby is a rough sport, it really doesn't help the appellant's claim. What that does is it supports a conclusion that all players may be anticipated to engage in rough play and that injury is not unusual. It says nothing, however, related to the probability of one player attacking another player during a stoppage in play. Nor is there anything in the proposed statement about rugby being a rough sport related to the registration requirements in this case. This is not a case about rough or dirty play. That may be foreseeable. This was a violent criminal assault where one man kicked a defenseless, unsuspecting person who was kneeling down in the face outside of gameplay. Rough play is to be expected. Criminal assault, felonious criminal assault, however, is not. Judge Brogman cited the Feedy case, which cited to Section 448 of the restatement, which says that a crime is a superseding cause of harm unless the defendant should have foreseen the crime. The plaintiff simply failed to introduce any evidence that would suggest that any of the defendants would anticipate that failure to observe the administrative requirements of maintaining the roster created a reasonable risk of criminal assault. Judge Brogman also cited, I believe, the cases Hill versus Safford and Chavez versus Tolleson Elementary School District, which also adopts the restatement's position that a crime is a superseding event unless it is to be anticipated. In that case, in Hill versus Safford, that was a case where one high school student attacked another high school student off campus. The court said a reasonably foreseeable event is one that might reasonably be expected to occur now and then, and would be recognized as not highly unlikely if it did suggest itself to the actor's mind. The facts in this case, the assault in this case, and the injury in this case were hardly reasonably foreseeable. Nearly unheard of. The coaches testified that they hadn't experienced anything like this in the past, and the plaintiff has not produced any evidence suggesting that assaultive behavior, such as what was experienced by the plaintiff, had been within the knowledge base or experience of any of the participants in this litigation.
Can you talk to me a little bit about this deposition testimony? I think it was Coach Lane, that the coaches do have some experience with this kind of or similar behavior. Can you talk to me about that testimony?
Only to the extent that my recollection of what's in the record and what's been presented to this court is the statement of the coach, or what was presented to the court below, was a statement of the coaches that they had never experienced anything like this before. With respect to that particular question, to be candid, I do not recall that particular question and answer, so I'm afraid I can't comment much further on that issue. With respect, continuing on the issue of foreseeability of a criminal assault like this, there's the case of Chavez versus Tolleson Elementary. The case that, although the crime in that case was one where there was a 10-year-old girl who went off an elementary school campus, was ultimately abducted and slain. So while the crime in that case was particularly heinous, the reasoning is somewhat similar. In that case, the court was unwilling to say that abduction and murder was a foreseeable consequence of a child leaving school grounds. Here, that same analysis is on point. Jordan Crawford's violent assault on Mr. Neary was not a foreseeable consequence of the defendant's failure to confirm his registration or eligibility to play.
So is your rule, and I maybe supported by the case law, that anytime there is a criminal act that is by definition unforeseeable?
Not at all. Not at all. As a matter of fact, that's what the restatement in the Feedy case says, is that indeed it is a superseding cause, unless it was foreseeable. And in this case, that was what was before the court. Was this a foreseeable assault?
By different under what circumstances would a criminal assault be foreseeable? I don't think that it would be a rare circumstance.
It certainly would be rare circumstances, and I think that would be what the drafters of the restatement and the authors of the Feedy case would propose, is that those would be a narrow class of cases where one would anticipate criminal conduct. Now, facts that don't exist in this case, but if it were a situation where there were facts in the record that Jordan Crawford said, I can't wait to go out there and beat the living daylights out of somebody from the U of A, those would be interesting facts. That might suggest the type of foreknowledge that doesn't exist in this case. In fact, the record with respect to Mr. Crawford is that he was a garden variety rugby player. He had played many games at Arizona State over several seasons and had never been ejected from a game, and in fact had never received a yellow card, a warning. He at all times had comported himself as any other rugby player. If there's anything that could have been anticipated by allowing Jordan Crawford to take the pitch that day, would be that he would conduct himself the way he had on all previous occasions, as a rugby player who observed the rules of rugby.
So on that point, let's take counsel's comments about this should have gone to a jury, because in some sense he didn't obey all the rules of rugby. He wasn't a student. He didn't register as required. So talk to me a little bit about these factual issues and why they don't require submission to a jury as opposed to the summary judgment.
The facts cited by the plaintiff that he was not registered with ASU and he was not registered with USA Rugby tell you nothing about his propensity for violence. The appellant's own briefing explains that registration through USA Rugby could have occurred from a cell phone at the field. ASU's Do Sports Easy system and USA Rugby's registration system do not propose to give any sort of background investigation with respect to the player's conduct or criminal history or anything of that nature. It's simply an administrative tool to make sure that the player is registered, they're eligible to play for the team that they've registered for, and that they've paid the requisite fees.
So, I take it you would disagree that propensity for this type of violence or some type of violence is required for foreseeability. Is that the position that you take?
Indeed, because that is the particular tort that occurred in this case, was a violent assault. And there's got to be, in order to impose liability for that act, for that otherwise superseding act, there's got to be some degree of foreknowledge or anticipation of something like that occurring.
The individual propensity for the actor, as opposed to, I think, what counsel is pointing to, the nature of the activity overall, which is admittedly violent. So you're saying that doesn't matter?
It only
or it's not
matters.
enough, I guess, is perhaps more.
I think what can be instructive is the Kavanaugh case that was cited in our briefing, and it was cited by Judge Brogan below. I believe it was out of Massachusetts. It was a college basketball game where one player punched another player. The tort in that case was one of, I believe it was failure to supervise or something. But the issue examined by the court was one of foreseeability. And the Kavanaugh court said some relevant things there, where they said that sports by their very nature seemingly always include some degree of foreseeability that in the heat of battle some player might lose their temper and strike another player. But foreseeability must mean something more than the ever-present possibility that an athlete may become overly excited and engage in physical conduct beyond the precise boundaries of acceptably aggressive play. Rather, a defendant would have to have specific information about a player suggesting a propensity to engage in violent conduct, or some warning that a player or players appeared to be headed towards such conduct as the game progressed. Again, these are particular facts relevant to Mr. Crawford. None of those facts were developed in the record below. Again, the only thing that we have with respect to the record on Mr. Crawford is that until that day, he behaved as any other rugby player that might take the field at that time. Just in the last few moments, I'd just like to take a moment to address a couple of factual issues that were suggested by appellant's counsel on this. Jordan Crawford was not a varsity player who was thrown down in the JV game against undermatched players. The record shows that Crawford played 7 games of rugby for ASU during that season, 5 of them at the JV level. There was no evidence offered that his designation as co-captain was anything other than a recognition of his exhibition of positive team attributes. And there certainly was no evidence offered that designating him as a captain somehow would make him more dangerous than any other player. There's no evidence that captains are more dangerous than any other players, and there was no evidence that unregistered players are more violent than any other players, nor is there evidence that a varsity player would be more dangerous than a junior varsity player. Finally, with respect to the quote that Mr. Crawford offered, that ASU had no jurisdiction over him, the full context of that quote is very important, and it's in your record. Mr. Crawford, hours after the assault, came back to the pitch to watch the varsity game between ASU and U of A. One of the coaches told him to leave, and he refused to do so. He was asked why did he refuse to do so, and he said, because I was there to watch my teammates play, and if I was no longer on the team, then he had no jurisdiction over what I was doing. I wasn't on the field. I was in the stands as a bystander, so I wasn't doing anything wrong. So the assault in this case occurred while he was on the team, before he'd been thrown off the team, while he was on the field. The only thing that his quote here suggests is that if he's not on the team and he's not on the field, then the coach can't tell him what to do. Obviously, to the converse, he's saying, if I'm on the team and I'm on the field, then that guy's my fault. That's not a quote that supports the appellant's argument. I'd like to give an opportunity for co-counsel to come up and speak with respect to the particular issues for their clients, unless this court has other questions for them.
That's fine.
Oh, and just very briefly, and thank you for this, we did raise in our brief an argument that the court mistakenly ruled that there was a duty offered by the student defendants to Mr. Neary in this case, and briefly put, that argument goes like this. The court found that there was a special relationship between the student defendants who were charged with maintaining the roster between them and the player from the U of A, and that they should have understood that management of the roster was necessary for the plaintiff's protection, and that failure to exercise the care increased the risk of harm, or that the harm occurred because the plaintiff relied on the defendant's undertaking. Well, while the court spent some time evaluating whether the student defendant should have known that the roster management was necessary for the plaintiff's protection, the court also ruled that the record established that nothing that was done with respect to the roster in this case increased the risk of harm to the plaintiff or any other player. In the absence of that level of proof, there cannot be the special duty relationship that is established in Section 323 of the restatement and Lloyd v. State Farm. So, again, unless you have other questions for me on that, I'll sit down. Thank you.
May it please the court, my name is Dan Shack. I'm an Assistant Attorney General representing the Arizona Board of Regents. With me is Deb Garner, also an Assistant Attorney General. I want to make 2 points regarding the superseding cause that I think might help you in reaching your decision. And the first one is a point about, it's not a criticism, it's a point about the way opinions are often written. And we often talk about foreseeability, but the true term is reasonable foreseeability. Just because something is imaginable does not make it foreseeable in the law of negligence. So we can imagine a meteor striking a building and injuring somebody. That is an extremely rare event, and one that would not be seen as foreseeable, requiring the owner of the building to protect against it. So it is here. Crime and intentional assaults on sports fields are of a different character than rough play. And on that point is something that Judge Fidel mentioned in Rogers, and that is that while juries are often left to determine matters such as this, the courts have to act as gatekeepers. They will draw the line. And in Arizona, which has adopted the restatement, crime and intentional torts are known as superseding intervening events, which break the chain of causation unless the defendant had reason to know of the danger, which is something you've dealt with Mr. Bergen here extensively. So in this case, there is no evidence that anybody should have foreseen that Mr. Crawford was going to commit the intentional felonious assault that he committed here.
And so the argument seems to be that rugby is of such a nature that human activity is reasonably foreseeable. I can see the same argument of being referred to other sports.
I do. Just because rugby is tough and a hard-hitting sport does not mean that it's expected that the players are going to intentionally assault each other to the point of a felonious assault. It's a point we made in our brief.
So counsel, we're getting to the heart of it now. It's a matter of degrees, isn't it? I mean, it's expected that at some point there will be assaultive behavior. I mean, what is the definition of assault?
Absolutely. And admittedly, you do have to draw a line. But the line is pretty clear in Arizona. We've adopted the restatement. It says intentional torts and criminal acts. Once you've gone across that line, then you're into the region of superseding intervening cause.
So then we use the club's guidelines or the acts that are listed as that which is reasonably foreseeable, and acts outside of those may not be?
You don't really. Well, yes, you want to look at the rules of rugby to see what's acceptable behavior, but
Or
the
foreseeable.
Pardon me?
Or foreseeable.
No, I disagree with that, Your Honor. Remember, it's reasonable foreseeability. It's not just that it's imaginable. Yes, we can imagine.
Reasonably foreseeable that a player may grab another player by the testicles, for example, because it's in the rules. So what the distinction I'm trying to draw is that the fact that there's a list assists to some degree in identifying what's reasonably, though perhaps illegal conduct, but reasonably foreseeable within the bounds of the sport.
I would not be willing to go that far, Your Honor. The rules would certainly not allow players to commit such acts, and certainly wouldn't allow a player to commit felonious assault. So just because they've addressed it doesn't mean it's reasonably foreseeable, and that's where the facts in this case establish it was basically unheard of. You've heard the testimony, you've heard it mentioned that the coaches have never seen this happen, and the plaintiff has shown no indication that this has happened. These kinds of assaults are extraordinary. That's what the point we made in our brief about Juan Marichal beating Johnny Roseborough in the head, or Kermit Washington slugging Rudy Tomjanovich in the face and
Counsel,
breaking the.
Your time has expired.
Oh, I am so sorry. Did you want? I'm sorry. Obviously, no further questions. I'll sit down.
Thank you. Counsel.
Thank you. I think that we've all really focused on what's important here, because it boils down to reasonable foreseeability. And I couldn't agree more with Mr. Schack, the AG, that it is absolutely about what's reasonable. And in this case, it is reasonably foreseeable that a player is going to commit a criminal act of assault. How do we know? The regulations go through specifically line by line. These are the things that we foresee have happened on rugby fields. Maybe Gary Lane and Coach Lopez hadn't seen this before, but it's
then we go back to the issue of degree. We
can
can reasonably foresee that there will be shoving, that there will be other types of behavior, but can we reasonably foresee that something like this would happen?
That's a question for the jury. It is reasonably foreseeable that the assault will happen, the level of the assault, because nobody is saying it was unforeseen that someone would get kicked.
But when it's something that has never happened before, don't we get to the point where it's so outside of the realm of the usual for this type of sport that the court has to say, we can't allow this to go to the jury because this is something that was not reasonably foreseeable?
Two things there. One is it's only not happened that these guys know about. No one is saying that this has never happened before. But the reality is
but we don't have anything in evidence
I agree
that
with
tells
you,
us that it has.
But an act has to happen for the first time for there to be a first time. In other words, what would be unreasonable, unforeseeable is a criminal act that rises to the level of a gun assault, a weapon on the field. That is so unreasonable that it's outside of the realm of foreseeability. A kick that increases from the level of being an assaultive kick versus a criminally assaultive kick, that's an evaluation that a trier of fact should have done. I apologize.
I might find an argument if in the course of play, a kick is too hard. But if it's a kick outside of play, I don't understand the difference between that and someone hiding a gun and pulling, out and shooting it. If it's outside the play, then it's a kick. If it's inside the play, then it's a kick.
But when we go back to the issue of degree, we can reasonably foresee that something like this would happen. That's the distinction I'm trying to draw is that
if it's outside the realm of play, I would think that you'd have a hard time saying that was reasonably foreseeable.
But here's the problem. It's not outside of the play. It wasn't during an actual play, but the players are still on the field in the game. It's outside the play if, like Chris Crawford said when he's sitting in the stands, I'm not on that field, so you no longer have jurisdiction. When you're in the midst of a game, during the game, it's still the course of play, whether the actual play that moment is stopped. You're on the field. You have play. But where we lead to, and the bottom line is this, is that the trial court and the defense would have this court create a bright line rule that says the only time there's ever any reasonable foreseeability of a criminal act is if someone shows a propensity toward violence. And that's not the law. The Kavanaugh case that they continually cite is very distinct from this case because that was a negligent supervision claim. And this question was, if I had a duty to supervise, I needed to have some warning or some ability to say, do I know this person has a propensity towards violence? That's not the same facts we have here. And this court should not create a bright line rule that says...
How is that question different than the question we are asking here?
Because they're saying that someone wasn't supervised properly to know, and I apologize because it's been a little bit of time since I read the Kavanaugh case again, but I remember in reading it going, but that is a totally different claim. It was, is the coach supervising to make sure that these kind of acts don't happen? And the question was...
But it is a question of foreseeability, which is our question here.
It is, but it's a different question because the question was whether or not the coach had a duty to the player to see, did this other person have a propensity towards violence? Here the question is, it's a direct duty. Did these coaches and student defendants have a duty to make sure that they weren't putting people on the field who could create an unreasonable risk of harm? And
putting people who are not registered increases the harm?
Absolutely it does. And that's why
he was less harmful, per your argument, when he was registered than he was later when he fell off of club registration?
Here's what we do know. He certainly didn't have the flagrant disregard for rules when he was registered, and he didn't go around flouting, no one has jurisdiction, I can do what I want.
Do we know that?
Absolutely. He said, I have the words to his effect are, no one had jurisdiction over me now that I'm off the field.
Do we know that before, when he was registered,
yes,
he said or didn't say the extent of others' control over him?
He didn't say it, but as Mr. Bergen pointed out, when he was registered, he followed the rules of rugby to a T. That's why he didn't have a yellow card or a red card. That in and of itself is evidence that when he was registered...
But in the record, he was not registered for a fairly significant period of time, at least this season. Isn't that what the...
That is true, but what we do...
And in this season, he had no other misconduct.
He had no other red cards. That is true.
Or yellow cards. No warnings.
That's right. That is absolutely true. But again, the question boils down to, do we create a bright line rule? And the answer to that is no. This is a jury case.
All right. Thank you for your arguments. We will take the matter under advisement and issue our decision in due course. Court is adjourned.